Hi, my name is Emily Sumner with Sumner Immigration Law. We're based in Richmond, Virginia, but we serve immigration clients throughout the United States and around the world. Today, I wanted to talk a little bit about the June 2021 Visa Bulletin, which was released just a few days ago. I'm going to be talking specifically about the employment-based Visa Bulletin and next steps that you might consider taking. The next step that you should take will depend on where you are in the process of becoming a permanent resident, of obtaining your employment-based green card in the United States. If you have already filed the I-485 application for permanent residence and your priority date is current per the June Visa Bulletin, then you want to make sure that you have your medical exam completed already if it has not already been submitted. USCIS will send a request for evidence for the medical exam, and you want to make sure that you have it in hand, ready to send as soon as you get that request for evidence, so that hopefully your case can be approved sooner rather than later. The second thing to know is interviews with USCIS for employment-based cases are for the most part being waived. That was a requirement that has always been in place, but the Trump administration decided to implement that for almost all employment-based cases. And fortunately, we're seeing that those are being waived right now. So you hopefully will not have to attend one. And then finally, remind USCIS, or at least consider reminding USCIS that your date is current as of June 1st. You can do that by submitting a service request, by sending a letter to USCIS, and then if necessary, sometimes if a case has not advanced within the time frame that we expect, we have the assistance of congressional liaison. If you are in this situation where your priority date is current in June and you'd like to remind USCIS that your priority date is current, coordinate with your immigration attorney. They can help you come up with the best strategy to implement to help remind USCIS that your priority date is current. Secondly, if your priority date is current in June, if your priority date is not current in June, but you have filed the I-485 already and you think that the date may become current soon, again, make sure that you have the medical exam done. The medical exam will be valid for a period of 2 years, so you can just keep it on hand. Don't send it in proactively to USCIS because it will get stuck in the mailroom and will not get matched to your file. And then secondly, consider upgrading your I-140 petition to premium processing if it's not already approved. This is something that you need to talk to your immigration attorney about before you make that decision. There are strategic reasons why you may or may not want to do that. Also keep in mind, it may not be possible to. If you have filed an I-140 EB3 downgrade, for example, and did not submit the original labor certification, because USCIS already has it. In some instances, USCIS is rejecting the premium processing upgrade request, saying that they don't have yet the original labor certification. They need to pull it from somewhere else. So it may not be possible, but consider that because you do have to have your I-140 petition approved before the I-485 will be approved. That being said, keep in mind that just having your I-140 petition approved, that has nothing to do with the EAD processing or the advanced parole processing. In other words, USCIS does not have to have the I-140 petition approved before they will approve those other documents. So just having the I-140 petition approved, let's say through premium processing, is not going to necessarily give you an advantage in terms of the work permit or the travel document. And then finally, the third situation that you might find yourself in is if your priority date is not yet current, but you think it might be soon, and you have not filed the I-485 yet. If you are in that situation, you want to make sure that you are positioned to be able to file the I-485 as soon as your priority date becomes current. That means that you want to make sure that you have a perm labor certification approved for the employer for which you intend to work. So if you had a labor certification that was approved for employer A that you had 10 years ago, and let's say you have an approved I-140 petition as well, and you've since moved on to employer D, three or four employers later, and you don't have a perm labor certification for employer D, again, talk to your immigration attorney and make sure that you have a strategy in place. It may be that you have every intention of returning to employer A when you receive the green card and employer A has that same intention as well. That might be fine. But if you have no intention of returning to that company, or they're closed, or whatever the case may be, you have to make sure that you have a labor certification approved for the employer for whom you intend to work long-term. Second, consider whether you need to file an I-140 downgrade or upgrade. So for example, if you have an EB2 I-140 approved, look at the visa bulletin. Again, consult with your immigration attorney. Think about whether the EB3 date may actually become current before the EB2 date, and it may be possible to downgrade, to file an EB3 downgrade in the I-140 for the I-140, a second I-140 petition. This is not an amendment to the I-140 petition, it's a second I-140 petition. But if you're able to do that now, then if and when that priority date becomes current for that particular category, EB3 for example, then you'll be able to file the I-45. You could also wait until the priority date becomes current and file concurrently. But again, it's a strategy to consider to go ahead and file the I-140 downgrade now so that you're ready to go when the priority date is current. And then finally, gather the documentation that you will need for the I-140, for the I-485 filing rather. That is things like your certified copies of your birth certificate. Don't submit originals to USCIS, but submit a copy, a photocopy of the certified copy of your birth certificate, your marriage certificate, have your passport, of course, ready to go, and updated copies of your most recent immigration approvals, your tax returns, W-2s, pay stubs. If you have all of those in a central location, you'll be less stressed when the time has come finally to file the I-45. Finally, in closing, the priority dates are moving quickly. Charlie Oppenheim is the person with Department of State who allocates the dates for the visa bulletin, and he has indicated that the dates, he anticipates that the priority dates will move quote unquote aggressively. That's the word he used, through the rest of this fiscal year. The fiscal year ends at the end of September 2021. And then the new fiscal year starts in October. So he says the dates will move aggressively for the employment-based categories as well as family-based categories. So you want to be sure that you're ready to go. If you have questions, please feel free to put a comment below, and we're happy to answer questions if we are able to. If you have found this video helpful, I hope that you will that you will comment, share, and subscribe to our channel. Again, I'm Emily Sumner with Sumner Immigration Law, based in Richmond, Virginia, serving clients throughout the United States and around the world. Talk to you soon.